Hello, Savannah. Thank you for tuning into WRUULP, Savannah, Georgia, 107.5 FM, WRUU.org. We are Savannah Soundings Community Radio with Global Soul. And welcome to my show, Real Estate Real Talk, with myself, Julia M. Spencer. I'm really glad that you're here. And on my show, we talk about anything and everything related to real estate investing. And if you were listening last week, I actually had brought in an interview that was conducted on October 21st with my attorney, David Basil, who is located in Carrollton, Georgia, who has helped me for many, many years with my tax sale foreclosures, with my borrowing of redemption rights, with my quiet title actions, and with lots of very, very good advice and information regarding real estate as it pertains to an investor. And on today's show, we're going to talk about the second part of our conversation. It was a very long conversation, so I had mentioned last week that we're going to split it up a little bit. Last week, he spoke a little bit about his background and what got him into this profession, into this career. And we talked also a little bit about borrowing of redemption rights and just in general, how the tax sale foreclosure process works. And on this show today, we're going to talk a little bit about title searches, why they're good, why they're important, and why a good title search is important, and what happens if you don't do it right, problems that can occur during a title search if it's not done properly. And we're going to talk about the quiet title action as well, which is the second part of obtaining ownership of a property that you purchase at a tax sale. So we're going to talk a little bit about Georgia law and also a little bit about due diligence and special masters. And in the second part of the show, I would like to speak a little, or let him speak actually, a little bit about these special masters, because I didn't actually know this information and I had to pay for one time. So we're going to get to that and to you everything that you need to know about special masters. And the reason this is important is that I have a lot of students, a lot of real estate investors that have come to me and asked me, well, can't I just do all these legal actions by myself and save myself a lot of money, because lawyers cost money, as we know. And this show will explain to you why you can, or why you can, of course, always, but maybe why you shouldn't. Let's say it that way. And we're going to talk a little bit of a couple examples of when a special master was needed in his work. And then we're going to, actually, he's going to explain a little bit of an anecdote of what happened one time when the county tax commissioner here, Chatham County, and the city tax commissioner had a little snafu and how it was resolved in court. So stay on for this show. This is a very important, very interesting show. And we're going to get right to it. He's going to start talking about, first, why title searches are important. Stay on. Here's the interview.
The consequences are that if you have 3 interests and you foreclose on 2, you didn't foreclose on the 3rd, that one is still available to redeem. You know, that becomes a real scary issue to someone who puts $40,000, $50,000, $100,000 in the property.
Right.
Mm-hmm. And say, what do you mean I can do that?
Mm-hmm.
And then we might have to go, we use a different protective device in those. But but sometimes what we have to do is, so if you don't do your title search correctly and you don't look and find all the available interest, you perhaps got a foreclosure that's not complete. Mm-hmm. But if you do find you come across, like somebody comes to me and says, well, I want to now quiet the title, which is the second step we haven't talked about yet. Mm-hmm. And we say, well, let me see what you did on the first step. Let me see your borrowment. And I look at it, and it may be done by a very reputable, it can be done by someone who is just the owner. I don't want to tell somebody that they didn't do a bad job on this, but we don't feel comfortable with this, and we don't think you foreclose on this interest. So what we may do, what you can always do, is do a second borrowment. And we've even had occasions where we've done a third barment. We felt confident that we did the second barment right, but we were in litigation over like 16 parcels. And we knew that they were not going to be redeeming them. It was just a litigation tactic. So we did it again. And then we moved for summary judgment, and they caved in at that time. But I've even had situations before where we're dealing with something now where we're doing a second barment where a property owner or the tax deed holder did the barment, then sold to a real estate professional. They sold the lot for $8,000. They turned around a month later and sold it to my client for $40,000. They had not done a quiet title. It had not gone through a lawyer, and the bargain was not complete. And what was more interesting is that my clients said, "Well, I said, well, what did this seller tell you, who was a real estate professional?" And they said, "Well, the seller told us that don't worry about it. I'm a real estate agent. It will be good." So do you have a possible fraud issue there, a misrepresentation?
Right.
A negligent misrepresentation, so if everything went south, meaning we go through the second barment, and someone wants to redeem, well, what price are they redeeming? What's the basis of the redemption? Well, it's on the tax sale, which may have been $2,000, even though they bought it for $40,000.
Right.
So that's really so you really find people at times that are really in an extremely precarious situation, and you just hold your breath while they do this. So, and again, there is another way that we do protect them, and in a quiet title manner, but it may protect the property, but it won't lead title insurance, in my opinion.
Okay, well, let's talk about the quiet title then, because I've had that. I've hired your firm to do that several times for me, and 2 times actually for 3 different properties. And one of the properties I think that went through your office was the same owner, so I got a special price on that one. That was really good.
Oh, I see. And you were very patient with me on that one too, I'm afraid.
That was the second one. That was the second one.
Okay.
Yeah.
So here is the anomaly that someone, and I'm not sure I'm using the right word. Here is how Georgia law looks at this thing. And it's somewhat, first of all, the tax statute. And the tax statute says, hey, when you complete the barment, you get fee simple absolute. That's what the tax statute says. But you go out and try to sell that property based on the barment, and the real estate community and the title insurance and the bank says, no, I don't care what the tax statute says. You need to go through a quiet title action.
Right.
And the quiet title action is, there are actually 2 types of quiet title. But we'll talk about what is a quiet title. A quiet title is, first of all, an equitable action, which means that it somehow began, to give you a little historical, and the equity arose as a concept with the English churches were set up as judges, because there was an inadequacy of dealing with certain actions, legal conflicts in England way hundreds of years back. And the equitable court started taking over things about, I don't know what they handled divorce now. I don't know what they did back then, but they would deal with issues of land, boundary line, legal description problems, things like that. Except, the King's Court would deal with contracts, injuries, things like that. But the church's court, called the equitable courts, the ecclesiastical courts, would deal with a whole another matter. So we've got the law this falls into an equitable action. And what it does, it says, the statute says, look, if you've got a title, real estate title, and you've got what we call a cloud on it, means that whatever is this fictional cloud is, it makes the title unmarketable, uninsurable, and you can't really sell it. And for this, and so they said, well, there's a process to make it cleaner and to quiet all of the liens and all the other complaining interests against your title. So there's a concept, that's what a quiet title means. Mm-hmm. And there are two types of quiet titles in the law. One is what we call a conventional quiet title, and then there's another one that goes a special master quiet title, superior title against the entire world. Now, just for practical terms, we'll just talk about the superior title against the whole world. That's a little bit more involved title. And by the way, the conventional title is what we call an in personam title, quiet title. You have to serve the person who has the interest that is the complaining interest. And that. Where the quiet title against the entire world is an in rem. It means it's against the property. Mm-hmm. And you would typically, what we call the venue, you would bring the action on the conventional where the defendant lives. So that you might have the property in Savannah, but you've got an interest holder in Fulton County. You would bring it in Fulton County. Mm-hmm. As opposed to if you were going to superior title against the entire world, you would bring it in Chatham County,
okay. Yeah, makes sense.
And let me actually go back and say one more thing about the barment here. So what you're required to do is when you deliver notice, I didn't talk about that, is that if you find people in the county where the property lies, they have to be served by the sheriff or a process server. If they're outside of the county, it's by certified mail. Uh-huh. So that's important to know too, and those are affecting the cost.
Right.
And you have to publish it once a week for 4 consecutive weeks. You can't foreclose in the 5th week. Right. And then there's also another standard that says, look, you've got 30 days to redeem it once you've been served notice. Mm-hmm. So we usually set our barments at about 8 weeks. Mm-hmm. We feel like both the publication window and the service window will close within those 8 weeks. And there's an expectation by the client that, hey, the job will be done.
Right.
So we set it at about that date, so we feel comfortable that those windows are closing. But those are more a little few moving parts. But let's move on to the quiet title.
And again, just really briefly, having the owners be served by a sheriff and the publication, all of this costs money. So a lot of people ask me too, is like, well, can I just do the barring of redemption rights on my own? I was like, well, you still have to pay for the sheriff to go out and serve, and you still have to pay for the newspaper, and you still have to do all these things and the proprietary websites that you use and services to do the research. So in a way, the charges that are being paid for a law office to do this, kind of a lot of the costs are those costs which you'd have to pay anyway. So
yeah, they're passed through.
Right, and right, exactly, and this is why I always advocate to use a professional to do this work instead of trying to do this on your own. Right.
Right now we have kind of we tell everyone it'll be about $1,300.
Right, exactly. Mm-hmm.
We charge a low rate of $750. Mm-hmm. And I say that because sometimes with my expertise, I've been awarded $400 an hour in court.
Right.
or on these matters. So, that's less than 2 hours worth of work. We put a lot more work into it. We just want to get clients. It's an introductory rate. Let me just say that.
Yeah.
So we tell everybody to do that because the $750 and the cost vary, anywhere from $350 to $750. They just vary. We just don't know until we get into it what the costs are.
Right.
But so what you've got is your borrowment. Let's say you're successful, and your borrowment expires, and you can take possession of it. So let's first of all deal with the client that wants to go forward with the quiet title. And then we can deal later with the client that what the other options are where you don't have to go through, or you could wait, or what can you do without a quiet title.
Right.
So we'll deal with the quiet title against the entire world. And basically what you're doing, among many things in the quiet title process, first of all, it's a judicial process, which means it happens inside the courtroom. The borrowment is a non-judicial process. It's in the newspapers. This is outside the courtroom. It's non-judicial. So you are basically, in your quiet title, one of the things you're doing is proving that you've done the non-judicial process correctly. And that will involve probably serving many of the parties that you had done in the borrowment, to say to them that you are now going forward with this additional process to clear the title. Now, why do we do this to start with? Let's take the 10,000-foot view. Why are we doing this? When it's a constitutional property issue. In the Constitution, we're entitled to life, liberty, and property. And they can't be taken without due process of law. Everyone knows that and is familiar with that. It's taught in the grade schools. Well, that's what we go back to. What is due process in particular with property? You don't pay your taxes. The tax commissioner is taking your property. Well, part of the process the tax commissioner has is a pre-sale due process. We're going to sell it if you don't pay, okay? Then it's sold. And then they have 12 months to absolutely acquire it without anything. Following that, you go through the borrowment process. The borrowment process is part of the due process. You have to use, and it goes back to there's 3 United States Supreme Court decisions that I could rattle off about this, but they talk about notice. How is notice provided to those that are losing their property? And that's where the reasonable diligence standard comes from. So what you're doing in the borrowment process is providing reasonable notice because you're taking that property. Effectively, the state is taking that property and handing it to you. You are in exchange for that, having paid the auction price and going through these other steps. And now the final step is you're going through a quiet title process. And you are, again, notifying them and if they came forward and said, well, I changed my mind, I want the property back. And you say, well, you know what? You're out of luck because we gave you a chance and we could prove we gave you a chance and we're entitled to judgment as a matter of law. And that's what occurs if you've given them notice. There. Now, there could be some people that come out of the woodwork and say, well, you didn't give me this and this and this. Well, there is some obligation on their side not to hide. They're either off the grid, they want to be off the grid, they want to run from house to house to house where you can't find them, you can't track, they don't have a utility bill, they're not telling the tax commissioner where they can be found, you can't find on the real estate record, you can't find all of it. That group of people you can deal with because it goes back to the notice. If you have made reasonable efforts in proving that, and what we usually do is we take all our efforts and we report it. and what we call an affidavit affecting title goes on the real estate records. It becomes one of our exhibits in the quiet title action, saying, look, we've proved we've done it, we've got all this stuff here, when we serve you, we're going to do that. So, but in a quiet title, superior against the whole world, what we do is the court, and this is always kind of gives me kind of a sly smile, because the General Assembly has recognized that judges don't have enough expertise in some matters to be looking over cases. And this is one, they don't have it. So what the law requires is that you appoint, the judge appoints a lawyer who is licensed to practice in that area with sufficient experience, and they could be in the circuit. So I don't know, I can't remember if Chatham is a separate circuit or not, but some of the counties in South Georgia or North Georgia will have several counties in its circuit. The only you have to do is be a resident of one of those counties there. So you appoint your special master, but you have to pay them too.
Right.
Yeah, right. So that special master, once they're appointed, has complete jurisdiction over the case to determine what the title problems are and how to resolve them.
Mm-hmm.
And I know that because I've wrestled with some judges who want to say what goes on.
Mm-hmm.
We cure the title, we do this, and they all of a sudden they want to get involved. You know, and it's usually the judges that have little or no experience. The judges that have lots of experience are going to say, "Hey, this guy's got experience. It's his problem.
Right.
He wants to repair this. I'll sign it. If he can't get it insurance, it's not my problem. It's his problem." Or the busy judges who will say, "Oh, this guy's a reputable lawyer. I'm gonna sign according to what he does there, and we'll go forward with that."
Right.
But the special master controls the case. So we have a special master in Chatham County we use often. We've got special masters throughout the entire state that we deal with. Sometimes we look for, if we get new cases, otherwise we'll look for special masters. But there are lawyers that we will use because they are familiar with this area. They can deal with it efficiently, effectively, and they understand how to get marketable title from a tax sale.
Right.
So we will employ them, or actually what happens is their fee is designated by the court, but you kind of work that out, you know, with them. And then they decide through what is called an entitlement to notice who will get service. And you have to serve all them, and then there's a publication that is required. On occasion, you will serve adjoining property owners. Now, it says that you have to serve that, and why do you do that? Well, if you're trying to adjudicate the boundary lines of the property. But if you don't serve them in a quiet title action against the whole world, that issue is unresolved. So if there's a joining property owner that says, "Hey, look, that's not the property line," and you'd say, "Well, I filed a quiet title." Actually, that's the whole world. And he says, "You didn't serve me with it." Well, that issue is not resolved by that quiet title action.
Right.
So you can either choose or not. And special masters have different, they're people too, just like judges. They have their preference. "Oh, we got to do this." Someone says it doesn't matter. And a lot of these things, like if you go to Chatham County or in Savannah, these property lines are well established over the years. So it's not as important to do that, even though the special master may want that. So what we do is we will serve everyone, and then we actually prepare what is called an affidavit of diligence. And that talks about, because most likely what you're doing in these quiet titles against the world is you're dealing with some unknown risk, some unknown error, because the person you're dealing with, or one of the former owners deceased, you don't have the type of knowledge that someone from the family does, and it's virtually impossible to get that unless you have boots on the ground, knocking on doors and doing that, and you just don't have the cost to support that.
Right.
So you do the best you can. You have unknowns. In some circumstances, the special master can appoint a person that is like a guardian ad litem who will represent minors and unknowns. Now, normally a guardian ad litem is appointed by the Superior Court, but this code gives the special master the ability to do that. Then you file your affidavit of diligence. You may, based on that, ask the court for permission to publish. The court gives you permission to publish. You publish. And you may have a guardian ad litem, depending on what the case looks like.
Okay.
A guardian ad litem to oversee the case. So, for example, in Fulton County, I had a case where the former owner, there were 8 dead people as the former owner, 8 deceased parties. So that was, one that when we finally resolved that, we probably want to put it in a frame and put it in the office.
Yeah.
It was just like, oh my gosh, that one's done. Everybody's breathing a sigh of relief. And
this last one that took so long that you helped me with, a special master was also appointed, and that quiet title took forever compared to the other one, and it was a significant cost for the master as well. And I didn't quite understand what that was. I'm glad you explained that just now. And thank you so much for staying with me here for Real Estate Real Talk with Julia M. Spencer. What you're listening to is an interview that I have conducted with my attorney, David Basil, on October 21st, 2024, regarding some of the processes that he's helped me with in the past with tax sale foreclosures. And you're listening to WRUULP, Savannah, Georgia, 107.5 FM. On WRUU.org. We are Savannah Soundings Community Radio with Global Soul. We're going to play a couple announcements, and we're going to continue the interview for another maybe 10 or 15 minutes. So please stay on and don't go anywhere.
You're listening to your radio station, WRUU, which is presented by people just like you, people from your community. The voices you hear are your neighbors, coworkers, and other Savannah residents. Therefore, WRUU is your community radio station. So won't you please help by donating whatever you can afford to help your neighbors stay on the air? Go to WRUU.org and support your local radio station with a monetary contribution of any amount. Again, you can support your local radio station at WRUU.org. Thank you.
Si un desastre natural llamara a tu puerta, ¿qué tan preparada estaría tu familia? No puedes cerrar la puerta a los temblores, inundaciones o huracanes y esperar que desaparezcan. Por eso es importante planificar ahora. Listo.gov tiene las herramientas y consejos que necesitas para preparar a tu familia para una emergencia. Así que si el desastre llama a tu puerta, estarás listo. Visita listo.gov y haz un plan hoy. Un mensaje de FEMA y The Ad Council.
Tune in to Way Left of the Dial every Monday afternoon here on WRUU from 4 to 6 p.m. for Music with an Edge with Tom. It's Way Left the Dial every Monday afternoon from 4 to 6 p.m. here on WRUULP 107.5 FM.
You are listening to your radio station, WRUU, which is presented by people just like you, people from your community. The voices you hear are your neighbors, coworkers, and other Savannah residents. Therefore, WRUU is your community radio station. So, won't you please help by donating whatever you can afford to help your neighbors stay on the air? Go to WRUU.org and support your local radio station with a monetary contribution of any amount. Again, you can support your local radio station at WRUU.org. Thank you.
Hey Savannah, get your music played on the radio. Yes, you heard that right. Get your music played on the radio. We here at WRUU 107.5 FM are looking for quality local music. Share your talents for the City of Savannah to enjoy. All you have to do is submit your songs to music at WRUU.org. That's music at WRUU.org. The only thing we ask of you is no explicit lyrics or content. So don't wait. WRUU in Savannah is excited to hear you.
And thank you so much for staying with me here for Real Estate Real Talk with Julia M. Spencer, basically broadcasting an interview I conducted with my attorney, David Basil, back on October 21st, 2024. And we're talking about anything and everything related to the tax sale foreclosure process. And in the first part of this show, we talked about title searches and why they're so important and what can happen if they're not done properly. He also touched a little bit on quiet title and how the Georgia law looks at quiet titles. And now we're talking about special masters. So we're going to continue the interview for another 15 minutes or so. And I will be right back after this. Kind of wrap it up. So stay on. Don't go anywhere.
No, I'm in West Georgia. I cannot, even though I've been awarded large fees. You know, if you're in downtown Atlanta, your special master is awarded $450, $500 an hour. You know, if they really know what they're doing. And the courts have no problem saying, yep. And then the special master says, don't worry about the fee. I'm filing my motion for fees in the court. You just wait and see what you owe.
Wow.
So I was like, oh my God, please have mercy on me.
Yeah.
My client. So we do a lot of the prep work. A tremendous amount of the prep work, which is different. I've seen lawyers do quiet titles where they get a special master appointed, they send the special master, and they expect the special master to quiet the title. I'm like, how? That doesn't work. The lawyer is supposed to prosecute the case.
Right.
So we prepare a lot of the stuff, reports, proposed orders, everything, so that the special master who is charging $500 an hour, you can effectively and efficiently look over it. So their costs, even though it might be that, are not that high.
Right. Yeah.
I remember one special master. I got involved in the case in Fulton County, and the client said, "Well, I didn't." She was already trying to quiet the title, and I didn't do the barment. She had done the barment. And the special master was charging $550 an hour. And so the special master had reviewed the case, done a title search, and ultimately come up with, which, you know, to me shouldn't have taken that much time, that you got to do the foreclosure correctly. You didn't bar the parties. You got to do that. And by that time, so she came to me, my client came to me, and the first thing I said is, you need to dismiss that case. And so I talked to the special master tried to talk me out of it.
Right.
Said, no, we can do this, we can do that. And I said, forget this.
Wow.
And then the special master got defensive. I said, look, I understand that you know what you're doing, but this is not beachfront property. You know, we're dealing with.
Right, yeah.
And I filed just a dismissal, which means the case ends.
Right.
Well, the special master filed her bill based on that, on all the things she's done, and she got a $6,000 judgment against my client based on that.
Wow.
So you don't want to walk around and do your own surgery on yourself, so to speak.
Right, exactly.
You want to get someone who's qualified to do it.
Right.
And there are some, real consequences. She had to pay that amount.
Right.
When she sold her property, because that special master knew exactly how to attach property, and anything she moved, it would trigger the payment.
Right.
So what happened, we move it through there, and if you need a GAL, which is a guardian ad litem, you use one. They will typically look at the case and say, how was the barment done correctly? Is there any way we can figure out if there are unknowns that the lawyer didn't do? I see the lawyer published against the unknowns with permission of the court based on his affidavit of diligence. We think the barment was done correctly. We see that what he has said in here we believe is true. And so any unknowns here, and only speaking about the unknowns, we feel like the job was done correctly. So we have no objection to the relief that's sought by the person seeking quiet title.
Right.
And then you move on to the report, and what we do with our reports to the special master we ask them to sign is the complete story. We want them to talk about the barment. We want them to talk about the adverse interest. We want to talk about how we tackled those adverse interests.
Right.
We want to talk about when the barment expired, how we served everyone in the quiet title. If they responded, how did we deal with that? Sometimes you'll have in the metro area, or even in Savannah, you may involve the city on it. And the city may just file something that says, look, we received this, and we don't have any interest in this sometimes. And sometimes they will say, we have an interest, and you have to say, well, your interest arose before the fact, so you're out.
Right.
And I have to get you. I have to do a little dance for you right when I say this. But let me tell you this first.
Yeah.
So then you get to the special master signs the report, and there is a proposed order that reflects a greater portion of the special master's report that the court is designated to sign. And the court signs that, and you got a complete title. And that is recorded on the real estate records. So anyone going through the title exam will know, hey, look, there is a quiet title in the real estate records, and that means it's going to be clear and marketable. Now, why do you do all that? It's because, sure, you want the clear and marketable title meets the standard provision of the GAR, the Georgia Real Estate Association's standard provision. I think it's Part 4. It says if you want to enter this transaction to buy and sell, you have to have a clear and marketable title. So check that off there where you got the quiet title there. That checks off. The next thing is you want insurable title. So the insurance company, well, really it's the title insurance company, gets involved in. Why do you want title? Why is there title insurance? Well, the bank, when you get your loan, wants their money insured.
Right, exactly.
They're going to loan $200,000 on this property for sale. They want to know it's insured. And who insures it? The title insurance company. Title insurance companies looked at one of our extensive special master reports and extensive final orders and can see the complete story.
Right.
Right there.
Right.
So that gives them confidence that the title is insurable and the transaction goes through at the closing table. And that's our goal there. But I've got to tell you this one thing here, and I know that Savannah is the first city, known as the first city of Georgia, and there's a lot of things, but I have a funny story about the city of Savannah. So what happens, and I briefly touched on it, the tax commissioner can sell properties at the auction based on city taxes. And in a place like Fulton County, they do. Where I am, Carroll County, there's 7 municipalities they do. And why do they do that, or how they do that? Well, as a local government matter from my municipal lawyer days, you have to sign an agreement. And the agreement's an intergovernmental agreement where they say, okay, the tax commissioner is going to do this job and collect all our taxes from us. And to that extent, is going to be processed through their office, and they issue us a check. So we don't have to hire the extra employees to do that. We just get the check from there. And if this property has to be sold, they'll sell it based on our taxes, and when it gets paid, they'll pay us. Okay? And then there's a provision in the law that the tax commissioner gets compensated an amount per parcel based on those agreements.
Mm-hmm.
But you don't have to do that. And in some places that they may or may not, they want to get along or not get along. I don't know what the situation is down there. But the city of Savannah was not on board with the tax commissioner. So my client bought a number of properties in tax sale. I'm not sure, it's 2016, 2017, something like that. And based on county taxes. So we went and barred and foreclosed on the city taxes. And there is a case from the Georgia Supreme Court says, look, if that occurs, the city has two options. They can redeem the property or they can get their money from the excess funds. But if they don't redeem the property, their lien is barred. Well, the city of Savannah didn't believe that applied to them. And I went down there and wrestled with the city attorney at that time, or the person assigned to me. And we actually, I made a motion for summary judgment based on the law. And the judge got my motion, and I had to go down to Savannah. It's a 5-hour trip.
Mm-hmm.
I had to go down to Savannah and argue the case. And I argued and said, look, this is all this. And the judge looked up, I think he's retired now, to the city attorney and says, why, Mr. is the city not barred from these taxes? And the city attorney's response was, we don't do that, Your Honor. The city of Savannah doesn't do that. I thought to myself, I have never seen that before. And the judge says, okay, all right, well, I'm granting summary judgment. And following that decision, which meant that all of the city taxes that were uncollected and could possibly be barred from collection, unenforceable, could be wiped out. The city started selling tax properties. How about that?
Right. And before they didn't.
Do a little dance and say,
right.
Well, this little fellow with hay in his hair over in Carrollton.
Right.
He doesn't know. He was probably in some sort of you can just call him Jethro over here in, West Georgia, doesn't know any better. Went and changed policy at the City of Savannah because they didn't do that. Anyway, I thought that was kind of a funny story. I hope your listeners don't get mad at me.
No, that's interesting. I didn't know that. So your client didn't have to pay for the city taxes, but at that point the city decided, let's start selling these so we can get our money.
Well, yeah, and more than that, when my client went to pay the taxes that were after the tax sale, they tried to apply it to the taxes that were unenforceable before the tax sale.
Right.
So I had to move for an injunction and an accounting.
Oh, wow.
I want all this stuff accounted for and repaid.
Right.
And, if you really want to have it out, I got the higher ground here. You guys have misappropriated these funds.
Right.
Not me.
Right. Wow.
Oh, I had them.
Yeah.
Oh, yeah.
You did.
Don't play.
That was a good win. That was a good win. Thank you so much for staying with me here for Real Estate Real Talk with Julia M. Spencer. What you're listening to was an interview I conducted with my attorney, David Basil, on October 21st, 2024, where we speak about tax sale foreclosures and some of the pitfalls and things that he's done in his practice over the years. We talked about title searches, quiet title, special masters, as well as a couple of nice anecdotes here from right here, Chatham County and Savannah. If you want to listen to the show again, it will be published at a later point in time on my YouTube channel. It's very easy to find. It's just my name, Julia M. Spencer. Or you can also listen to the show again on wruu.org. If you go on that website, check archives, go to Wednesday and scroll down to the 12:06 p.m. slot right after the happiness message, and I will be publishing the shows there as well. There's a first part to this interview as well, which we had broadcast last week, and that particular show will be also at that location. And there will be a third part coming as well. This was a long interview. So please tune in again next week, Wednesday. We're going to have the last part of this interview. If you have any questions, comments, or suggestions, you can always reach me at julie12366@gmail.com. You can also leave any kind of message on my YouTube channel to any of my videos, and I'll see it there. And I'll be happy to forward them either to my attorney or answer the question myself if I can. And of course, he can be reached at basillawgroup.com. And also, he's located in Carrollton, Georgia, so his phone number and everything else is there as well. And you can reach him also directly if you have some specific legal questions there. And thank you so much for tuning in. You're listening to Real Estate Real Talk with myself, Julia M. Spencer. Next up on this station, you will have Gypsy with some really cool music, so don't go anywhere. I will be back next Wednesday. Enjoy your day. Bye-bye.
For your free guide to real estate investing, visit juliamspencer.com.